Good afternoon, everyone joining in this session. This is the second session of day 4 of the India ADR week. My name is Bilshan Nursimulu. I'm a barrister from Mauritius, and I'm also a member of the steering committee of the YMCIA, and very pleased to join the ADR week virtually from Mauritius. The topic of this session is the question of whether India is a potential market for litigation and arbitration funding. This session is being hosted by Innsworth Advisors Limited. Innsworth funds high-value commercial litigation and arbitration claims across the globe. And in a few minutes, I'm going to introduce the speakers. While I'll do that, I've been asked by one of the speakers today, to do something slightly different. I won't say who, but I've been asked that as I introduce the speakers, I will also ask each one of them to say something about themselves that we won't necessarily find on them if we Google their name. So let me start with Darshandev Singh, who is a partner with Lee, Hishammuddin, Allen and Gledhill. His primary area of practice is commercial dispute resolution with a focus on complex disputes relating to construction, engineering, oil and gas and infrastructure projects. Darshandev, can I ask you to say something that we won't find on you on Google?
Thank you, Bill. Thank you very much, Bilshan, for the introduction. Well, a fun fact about me that I won't find on Google. I love something which is adventurous. And when I was back in the university, I joined the cadet police force. It's part of a curriculum activity. And that required us to basically head into a thick forest. And we were there for a week. And we were only given one pair of a green jacket with a green pants. And of course, my mom, being my mom, she told me, why don't you get some extra t-shirts that you could change the t-shirt while you can wear the same thing, which after 3-4 days, it started to smell. So there was a particular night where we were actually sleep in the tent. See how the tents were built, that there was like a small netting at the top. That's for the light to come in and for the air. And when I woke up, I saw a huge fat leech right up on the net. And I was telling to my friend who was actually sleeping next to me, and I said, wow, the guy seemed to have had a feast, you know, in terms of the whole night. And I would just ask him, so did you get bit or was it me? And when I looked down at my thighs, there was a huge blood spot. So I think he was there and he had been sucking my blood for the whole night. And yeah, so he was just finding his way up slowly after having a good buffet. So yeah, that's something, one of the things that happened to me many years ago.
Thanks, Darshandev. That's definitely something we won't find about you on Google. And the next panelist I'm introducing is Sherina Petit, who is the head of India practice and a partner in international arbitration at Norton Fulright. She also leads the arbitration practice across Asia, Europe, and the Middle East. Sherina, can I ask you the same question, something about you that we won't find on Google?
Thanks. Just as I finished law school at GLC in Bombay, I probably had the largest clientele, even more than the senior counsels at the time, and that was saving the stray dogs of Mumbai and Navi Mumbai before the Bombay High Court.
I'm surprised that that's not on Google. Maybe it will be from now. The next panelist is Shreyas Jayasimha, who is the founding partner of Aarna Law. Shreyas is an advocate, arbitrator, and trained mediator based in India. And Aarna Law is a boutique counsel-led international and domestic dispute resolution practice. Shreyas, you know, the same question is coming to you. One thing we won't find about you on Google.
I grew up in part of my city, Bangalore, playing a traditional South Indian drum called the mridangam. And that's instilled a sense of beat, which hasn't gone.
Thanks. That's very interesting to know about you. The last but not least panelist is Sindhu Sivakumar, who's the Senior Investment Manager at Innsworth Advisors. As I mentioned earlier, Innsworth funds all types of high-value commercial litigation and arbitration claims across the globe, including insolvency, intellectual property, and investment treaty claims. Before I hand over to Sherina, who's going to be moderating this session today, just want to remind everyone attending that it's being recorded and transcribed. And so Sherina, over to you, and I'll see you at the end of this session.
Thank you very much. So good morning, good afternoon, good evening, everyone, and depending on which jurisdiction you're dialing from. It's my pleasure to be hosting such a topical session today as part of the YMCIA's ADR week. Is India a potential market for litigation and arbitration funding? And a big thank you to our sponsors, Innsworth Litigation Funding. I very much hope that you will find the session interesting and knowledgeable from my personal perspective. It's been a pleasure to work alongside and moderate this excellent panel with these esteemed speakers. In terms of structure, what the speakers and I thought we'd do is kick off by giving a short overview of how third-party funding operates across different jurisdictions. And then to spruce things up, we'll move on to a scenario involving ADR and third-party funding, and perhaps have a bit of a role play there, and then have an interactive round of questions that I'll be putting to the panelists, followed by questions from you, the audience. So let's keep the session interactive, fun, and keep those questions ready. In terms of an overview, I thought I'd just briefly touch on the UK, and then I'll hand over to Darshandev. Although third-party litigation funding is relatively new in the UK, the uptake is being surprisingly strong and now holds a firmly established pace in the UK legal market. In fact, I was reading some statistics, and it seems that there are more specialist litigation funding companies than in any other jurisdiction. The welcoming response to litigation funding has driven England and Wales to become actually one of the first and only jurisdictions to have something called a code of conduct for litigation funding. And this is overseen and enforced by the Association of Litigation Funders. The code was launched in 2011 and sets out certain standards of practice and behavior for litigation funders. Although it's not mandatory, the code contains a number of provisions, including but not limited to funders' capital adequacy, managing disputes over termination of funding arrangements, conflicts of interest, including the requirement that it is the client ultimately who remains in control of the litigation. It's also important to note that the code was designed to be more of a temporary measure before perhaps stricter statutory regulations are drafted. So what and who is third-party litigation funding interested in? Despite a significant growth in recent years, the third-party funding in England and Wales does not extend across all claims. It's primarily used by commercial claimants in terms of monetary claims that can be monetized within a short period of time after proceedings end. Claims such as, therefore, personal injury and other consumer-based claims on economic and policy grounds are not funded. It's true that funders in the UK will generally only fund claimants. However, I think as the UK funding market matures, there will be, and there looks to be, an uptake in the amount of defendants that will actually be receiving funding. And that leads to a number of requirements that have to be met before funding is given. These include a sizable counterclaim, the defendant having a portfolio of litigation matters supported by the same funder, as well as the defendant agreeing to give the funder a stake in a future asset or income, which is expected to flow from the successful defense. So about the future of the UK litigation funding market, I think the inescapable narrative is that COVID is no less applicable here. The cash flow pandemic that this disease has caused will greatly impact the prevalence of funding, as financing both existing and future claims is becoming even more difficult for many parties. And therefore, acquiring third-party funding seems to be a natural response to the ever-growing pressure to free up cash and take costs off the balance sheet. And we're finding lots of clients that are coming to us with the question, can I get funding? So with this growing presence comes the need for greater regulation as large swaths of funding remains unregulated. A number of institutions are addressing this issue specifically by seeking to clarify the duties and obligations of third-party funders. So with the continuing rise of third-party funding and the potential conflict with the arguable limited current regulation, I think the future of litigation funding in the UK is certainly one to keep an eye on. Darshandev, moving to you, is third-party funding permitted for arbitration seated in Malaysia, and how prevalent is it? It would be great to hear your insights on this.
Thank you, Sherina. I would say, unfortunately, third-party funding has not been introduced in Malaysia. Having said that, the very reason is because I think we are still stuck with the doctrine of Petit and maintenance. But there has been a move by the Malaysian Bar and the AIAC in the past to introduce or at least amend the Arbitration Act or the relevant legislation to introduce third-party funding in Malaysia. As an arbitration practitioner myself, I do see a dire need for third-party funding to be introduced in a jurisdiction, particularly when it comes to international arbitration, in light of the fact of there's been a rising cost as far as international arbitration is concerned. And of course, I think the point that you've made, Sherina, is with this global pandemic that has affected cash flow of many organizations and many companies. And companies may be looking at basically managing their risk in a sense where having a third-party funder coming in to fund at least the whole or part of the litigation so that the balance excess money could be used to invest in some other parts of the company in order to get the company moving and alive. So yes, we are pushing on, we are trying to introduce third-party funding, but as yet in Malaysia, there's yet to be a clear directions towards third-party funding.
Great, that was excellent. So I know that you cover quite a lot of Asia. Could I be cheeky enough to tell us about Singapore and Hong Kong as well? I know those are two jurisdictions that are, forging ahead the rest of the world, in fact, in terms of third-party funding. So could you perhaps run us through why this may be the case and what other countries may be able to learn from them?
Sure. Thank you, Sherina. I think if one were to look at Asia, one of the two countries that one could look at as a guidance would be Singapore and Hong Kong. Of course, in UK, as you correctly pointed out, you've got the ALF code that's in the UK. But as far as Asia is concerned, I think Hong Kong and Singapore has, to a certain extent, amended their legislation, introduced regulations, introduced codes in a way how to regulate third-party funding activities. I wouldn't say it's a comprehensive thing, but at least it's a good start somewhere. Like for example, in Singapore, they've actually amended their legislation to allow for third-party fundings in international arbitration and court proceedings which relate there too. In fact, I think about 2 years ago, the Singapore law minister has basically announced that it will now also be extended to domestic arbitration as well as proceedings under the SICC, the Singapore International Commercial Court. As far as the key takeaways that I can see from both these jurisdictions, they are in a way quite similar in terms of their regulations and codes. But for example, like in Singapore, I think they've actually defined how do you actually qualify to be a third-party funder. So you first need to qualify as a third-party funder, and not just anyone could actually come into a definition of a third-party funder. And in Singapore, I think you have to have a paid-up share capital of assets of not less than 5 million Sing dollar, and you must be a person who carry on businesses of funding, of course, of disparity to which the party is not a party. That's one aspect of it, and I think Hong Kong is about 20 million Hong Kong dollar, if I'm not mistaken. Then the next part comes to is the deals with managing conflicts of interest. I think in Singapore, the regulations are that the funding agreement must recommend that if there is a conflict between a third-party funder and the client, how do you then deal with such situation? And I think that the recommendation there is that a lawyer who is assisting a client who is being funded must be entitled and must not have any pressure from the third-party funder, that in the event there is a conflict, the lawyer can still continue to act for the particular client, and there's no interference as far as the third party is concerned. In fact, I think the regulation also goes on further to say that the third party shall not influence the lawyer in the way of when it affects his professional duty. One of the interesting things in Singapore is that they've also said that lawyers or law firms who are involved in that matter are prohibited from holding any share or ownership or interest in the third-party funders company. But having said that, they can actually introduce third-party funders to their client. One would then ask, what sort of interest are we speaking of? Is it a direct financial interest or is it an indirect financial interest? I think the regulation here defines what the financial interest to be a direct financial interest. But we know in reality, there can be indirect financial interest as well. For example, there may be a particular set of lawyer or a law firm that works very closely with a particular third-party funder, and in a way where most of the arbitrations are where they work as a team. So that can be an indirect interest as well, if one were to look at it from that perspective. Yeah, but in terms of Singapore, it seems to have defined it to be direct financial interest. And of course, both in Hong Kong and Singapore, there is a duty of disclosure that you basically got to disclose to the arbitrator and the arbitral tribunal and your opposing party at the commencement of the arbitration or as soon as practicable. If I'm not mistaken, either Singapore or Hong Kong, I think it's Hong Kong if I'm not mistaken, and once the third-party funding arrangement ceases for whatever reason, the duty lies on the party who was funded within 15 days to notify the tribunal and the opposing party. I think it's in Hong Kong. And you've got to do that. Some of this regulation also goes on further to basically encourages or recommends what are the things that ought to be included in a third-party funding agreement, as far as who calls the shot, who makes the decision, to what extent will the cost be borne, the liability, etc. But interestingly, as far as Hong Kong is concerned, although they've provided this requirement, there is a provision in there. We say that if anyone does not actually comply with the code, it's not something that is subjected to court proceeding or judicial proceedings, but it can be taken into account by the arbitral tribunal when it comes to determining particular matters. So to basically, in a nutshell, whilst there are a lot of guidelines, there's a lot of measures, there's a lot of recommendations to put in place, to what extent would it be enforced? To what extent would it actually be effective? That's something that has yet to be seen and would have to be explored on a case-to-case basis. But having said that, I think as a good start, there is some guidelines that show some guidance that have been put in place in both these jurisdictions, Singapore and Hong Kong, that for any jurisdiction, not only India but also Malaysia, would want to actually go into or kick off into state-party funding, could start off looking at these two jurisdictions as a guide.
Thank you so much, Darshandev. That was a fantastic whistle-stop tour of 3 jurisdictions. So thank you very, very much. Shreyas, over to you. You're a founder of a firm in India, and actually one of the pioneers of actually founding a firm in Singapore as well. So I'd be extremely interested to hear your views and your thoughts around third-party funding in Singapore and Hong Kong. If there's anything you'd like to add to what Darshandev said.
Thanks, Sherina, and thanks for the shout out to Simha Law, which we were privileged to establish in Maxwell Chambers in Singapore. And it being in part of the arbitration ecosystem in Singapore is feels like sitting on a magic carpet because there's so much energy part of the ecosystem which has nothing to do with you. So it is very invigorating for sure. So one point is that the ecosystem as a whole is geared to beyond just regulation, but be it best practices, be it just plain intention of all actors concerned, to put in place efficient and effective dispute resolution processes. And that is palpable even in the third-party funding context. So you do have, for example, guidance notes from the SIARB touching upon third-party funding. And in Hong Kong also, there has been an attempt to have a code. But one thing that is striking is this, as Darshandev precisely put it, the need for disclosure. And so I think in that sense, the two jurisdictions are hinting at an Asian way, if I can put it that way, of being comfortable with third-party funding, but also being ensuring that it is not operating in an unregulated context entirely. And so I think this will certainly inspire other jurisdictions to look more closely. And the very fact that we're having panels like this, and this is not unique, this is happening every week or every fortnight in India, and that tells you how the ground is shifting in this jurisdiction.
Thanks, Shreyas. And let's come back to our home jurisdiction, India. Is third-party funding permitted for arbitration seated in India? What do you think?
Yes.
Or rather, should I say, not is it permitted, it's happening. So to comment on that.
Yeah, thanks. I was going to rephrase it in some similar line myself. Because until we have a definitive court pronouncement, we can all be entitled to our views, but wouldn't be able to say absolutely beyond doubt. But it is clearly true to say that there is no explicit either prohibition nor an express permission, to TPF per se. But the cases are all well worn, but since we do have nearly 100 people in the audience, I'm betting that a few maybe have not seen some of these decisions. So pardon me, the panelists, especially Sindhu, who would have heard this every single panel that she's been on TPF. But the cases in India go back beyond just the last century. So the cases, for example, of the Privy Council in 1876 of Ram Kumar Kundu, acknowledging that a fair agreement to supply funds to carry on a suit in consideration of having a share of the property, if recovered, may not be opposed to public policy. Decision later in 1954, the Supreme Court in Re G, senior advocate, drawing the distinction between championship and maintenance, but also showing the limitations, the additional limitations on legal practitioners per se, and therefore perhaps hinting that others are not as prohibited as legal practitioners are in funding cases. And then the throwaway line that we've spoken about so much in A.K. Balaji in 2018, noting that the funding of third party of litigation is certainly happening in India. But the Bar Council rules per se, especially Rule 18, talking about fomenting of litigation, Rule 20 on contingency fees, 21 on share or interest in an actionable claim, 22 in participating bids in execution, all strongly suggest that at least lawyers themselves can't fund the claims. So that is, a few takeaways emerge. One, that the funder cannot be a lawyer. Two, that there ought not to be some influence on the outcome of the proceedings. There can be concerns as to how the money is deployed, and certainly whether it is a funded case or any other the sensitivities on making sure that the adjudicators are entirely immune from any financial pressures is important to retain the credibility of that dispute resolution mechanism. Also, the question of whether the funder would have a finger on the trigger, as it were, to pull the plug if arguments are on entirely shutting out the claim entirely, is maybe to, for example, avoid a further outcome in adjudication, which would be unwelcome. Those are all considerations which I'm sure a mature market, a regulated market will, and when I say regulated, I'm not necessarily saying state regulation. It could even be self-regulation. But the absence of either state regulation or self-regulation is, in my view, not healthy. And it does ultimately impact the credibility of even the more mature players who might want to have access to justice arguments made if there are funders who are less concerned about these aspects. And finally, the fairness of the agreement of funding itself. I'm sure these are factors that will be considered in the cases that will ultimately come up before court to answer the question more definitively that Sherina posed.
Thanks, Shreyas. That was great. I know you've touched upon this next question already, but what are the factors that may have made third-party funding less prevalent in India? Anything to add to that from what you just said?
Yeah, first is, of course, this ambiguity or hesitation around giving an explicit answer to your first question, especially looking for a case that says it per se. But having said that, if you look at the activity, as you said, on ground, it's only increasing. And so the bets are being taken, money is being placed on a position, perhaps, that the courts will come out in upholding the validity of certain funding arrangements. And that seems to be the trajectory. The other aspect is the certain regulatory aspects of concerns of if, for example, a foreign funder is funding a claim, then if there would be fund repatriation issues that they might face when it actually comes to counting the pennies. And again, the more examples we have of funders being able to successfully repatriate whatever was earned out of an arrangement, those anxieties might come down. But I think till that happens in a more publicly accessible fashion, the reason for some anxiety or hesitation is ambiguity.
Thanks a lot, Shreyas, for that. Sindhu, moving on to you, and you're, you're the only funder who's on this panel. So looking at funding from the eyes of a funder, could you perhaps give us an understanding of third-party funding that we won't find in books or journal articles? For example, how is it different to a traditional bank loan?
So when we think of funding, I think we think of litigation finance as any arrangement really where a third party to a litigation, which can be a professional litigation finance company like us, but doesn't have to be, provides funding to a litigant to run a case and in exchange shares in the results of the case, essentially. So if the litigant is successful, we take a portion of the winnings. If they're not successful, we get nothing. And the last point sort of that I said, which is, if the litigant is unsuccessful, we get nothing, is essentially what distinguishes us, litigation finance, from a bank loan. Now, a litigant can obviously take out a bank loan to finance a case, but with that, you'll have to pay the loan back with interest, whether or not your case is successful. Whereas a key aspect of litigation finance is it's non-recourse. So the risk of loss is entirely with the funder, not the litigant. And if they lose the case, they don't have to pay anything. There are pros and cons to both. Not to say one is superior to the other. TPF can be a bit more expensive to a traditional bank loan. There's no doubt about that, but it's a much better risk proposition. Also, bank loans may simply not be available in a lot of litigation cases because remember, banks often want some sort of additional collateral separate from the litigation, which litigants may not be able to provide. Whereas in litigation finance, the litigation itself is the only collateral. We don't seek additional collateral typically.
Thanks, Sindhu, for that. So would you as a funder give us an overview of how you broadly see India as a market for third-party funding, and perhaps outline some of the positives and negatives of practical examples where you funded cases involving India?
I can give you a sense of how funders, international funders maybe in particular, perceive the market. I think there is no doubt that international funders are interested in the market. The very fact that we're having this panel discussion and that there have been so many such discussions around funding, Shreyas mentioned this as well, shows there's a lot of interest in this market and people are spending time investigating this market. In terms of what people are doing right now and what they're most interested in, I think there are several funders who will look to fund Indian parties with respect to their disputes abroad, so foreign litigations and arbitrations. That's an active, thriving market. These aren't always the easiest transactions to structure for a funder, particularly if there is interaction with India's foreign exchange regulations, but there is significant interest here. Increasingly, I think funders are getting interested in domestic arbitrations in India, driven in some part by all of the arbitration reform and the positive judgments that have been coming out of India in the last 4 or 5 years, I would say, and for the same reason, I think there's been increasing interest in enforcement actions of arbitral awards, both domestic and foreign awards. With pure domestic litigation in India, I think it's safe to say there's less interest there. For a number of reasons. I mean, everyone talks about the delays associated with litigating before the Indian courts. And then there's also the perception, right or wrong, that you often get unpredictable judgments from the courts. And that's something that makes funders wary. Positives, negatives, not really positives or negatives, but I think there are, with India-related disputes, there are a couple of things I think funders should be aware of, unique issues, if you will. For example, and you'll have to keep in mind foreign exchange regulations when funding an Indian entity, which some international funders can be quite unfamiliar with. With sort of any India-related arbitration, you'll need to consider the interaction with the Indian courts, where that might arise, and if that's something you can live with. And I think, with like enforcement actions, which are getting increasingly popular, you'll also need to understand that, India has a lot of different local courts, and the different local courts are not all equal. You'll need to have a good understanding of the different local courts, the differences between them when considering such opportunities. I will say one thing, sort of, and touching a bit upon what Shreyas said before. In some ways, legality is not a huge concern. The broad consensus, I would say, is if you look at all of India is not unique in the sense of not having express permission for funding, and that's something funders are used to dealing with jurisdictions without express permission for funding. The judicial dicta, by and large, is positive. I think it says a couple of things. One is, champity and maintenance don't really apply in India in the same way that they did in Singapore or Malaysia. And the restrictions, to the extent that there are any, seem to primarily apply to lawyers being involved in funding. So lawyers having a contingent interest in funding, not with third-party financing claims, of which I don't think there are many professional funders, but the concept has existed and seems to have existed for a long time in India. But that said, I mean, there is one thing, right, which is to the extent that there is ambiguity, as a funder, one of the things I would be thinking about is, am I funding a case involving potential enforcement in India, i.e., if an Indian defendant is involved? And if so, does this ambiguity give them scope to essentially exploit this ambiguity and obstruct enforcement in India? So that's a more practical consideration, I think.
Thank you, Sindhu. That was great. I mean, thanks, Sindhu. Thanks, Shreyas and Darshandev for the incredible, valuable insights. I think we've got quite a few takeaways, and I can see questions are coming in from the audience. Let's now move on to the next section, which is ADR. And particularly given the umbrella topic for this week is ADR, let's now discuss the impact of third-party funding on settlement. And perhaps maybe let's walk through a hypothetical scenario, maybe not that hypothetical because I actually experienced this. So there's a dispute between two parties, and naturally we have a lawyer, we have a client, and we have a funder. So let's say that the claimant has a good case and therefore has secured third-party funding. The respondent has a fairly weak case, fairly weak, not very weak, but fairly weak. And therefore has agreed to go through to try and settle the matter through mediation. Now let's have a think of how this plays out, specifically looking into the aspects of the claimant's position that it has procured third-party funding, and the respondent's position that it knows that the claimant has procured this funding and effectively already has a buy-in from an investor that the chances of success are 60% or more. So Sindhu, could you let us know your thoughts from a funder's perspective? Do funders promote settlement?
I mean, I think having a funder by their side can be very helpful for litigants during the settlement process. If you think about it, a funder is primarily interested in achieving a financially optimal outcome. And that's usually what the litigant is interested in too. Not always, but arguably those sorts of litigants should not be seeking funding in the first place. So broadly speaking, as far as the funder and the litigant are concerned, their interests are aligned in evaluating settlement offers. And in the evaluation process is, where in our experience, litigants often are often reliant on us and often value our contribution. I mean, because there are a number of things you want to consider either when deciding whether to make an offer, how much to make it at, and equally in evaluating an offer made from the other side. Now, what are the costs saved by settlement? So by avoiding trial, essentially. What's the level of the offer versus what you might achieve at trial? What are the merits of the case? What sort of a result do you expect at trial? Funders are very used to modeling these sorts of scenarios and assessing settlement offers. So having them involved can be helpful for a litigant who might not have quite so much experience with them. And apart from, I think, just the assessment process itself, again, funders go through a lot of settlements and they can be helpful in the negotiation process as well, just bringing their experience to the table. That again, for the inexperienced litigant, that can be hugely helpful. And ultimately, I think, it sort of depends on all the parties involved, the jurisdictions involved, as to how involved or not the funders will be in the process, because not all jurisdictions will allow for it. But I think in our experience, when it's done right, it can only be a positive, and it's good for the litigant.
That's great to hear, Sindhu. Now, Shreyas, your thoughts from the perspective of a client and counsel to the claimant, and also if you can then put another hat on and then look at it from the respondent. Darshandev, I'm warning you, I'm going to ask you the same thing as well next. So Shreyas, go on.
Thank you, Sherina. Before I address this, I just want to quickly pick up on a point that Sindhu made on the last matter. I was delighted as a lawyer practicing outside Delhi and Bombay what is called Mufassil courts. You see the rest of the civil courts in India are called Mufassil courts, boondocks. And the practices vary tremendously. And especially in relation to TPF even, there are certain amendments in certain states in the Civil Procedure Code itself, which might include implement of financiers into the litigation. So I'm sure in due course that might be explored a little more. But back to your role play now. The scenario that you have traced puts me as the counsel for the claimant in an excellent position. You have given me, Sherina, a strong case. Thank you very much. You have also given me access to funding. So not only do you and I think we have a good case, but there's a funder in the room who agrees with that view. And so that can lead to some irrational thinking unless we are careful. It's not easy to exercise humility, and the first thing is to know that in your scenario, you said, if I remember, you have a 60% chance of success. Now, that does still mean that there's a 40% chance of failure. And quite often, that is lost sight of. And so the first thing I would advise is to, which I always do, is to ask my clients to become emotionally aware. And so I say, please look at the Dalai Lama's Atlas of Emotions. It'll tell you to put a name on your inner weather system, whether the winds are blowing strong or gentle. Calm down. That's when you're best placed to make rational decisions. Next, assess whether this 40% is a real risk. And thankfully, there's a funder in the room, so there is no recourse funding available to me, even to deal with this risk of 40%. And so I am therefore empowered, I feel more empowered perhaps to suggest that we can conduct confident negotiations in the settlement process, but knowing that there is some downside protection if the settlement negotiation fails. Finally, in any settlement, the point of having future business is important, and also of a reputation as a inveterate litigant or as a person who finds value in any business situation. And I would counsel the claimant to say that if the reputation gets built over time, that even in a difficult situation, this is a claimant who will reach out to find value, even in a dispute. Then that reputation itself builds long-term reputational and real economic value to the enterprise.
Thanks, Shreyas. Darshandev, do you have anything to add? What do you think? Do you think third-party funding promotes or discourages settlement?
I think the answer is it depends. There are certain plus points in third-party funding, especially in the scenario that you've mentioned, which may promote settlement. And one of it is what Shreyas has mentioned, which is when a third-party funder is on board, the impression that you get upfront is that at least the other party who is being funded have a reasonably good case, or at least 60% or more. So if you as a respondent have I wouldn't say a terrible case, but at least a fairly weak case, so that could be one of the consideration that you could consider in trying to resolve matters amicably as opposed to pushing on. Because this will also be a situation where the claimant would not run out of funds. So you won't have a situation where if you were to drag the arbitration and with the cost of experts, etc., coming in, it may eventually frustrate the claimant, but that will not be the case here because he has a third-party funder involved. So that actually promotes settlement. In fact, it puts the claimant slightly in a higher bargaining position. But having said that, what if we are faced with a scenario where the settlement offer that is on the table may be in the best interest of the claimant. And had it not been for a third-party funder, it would have been the best thing that the claimant ought to have done. But because of the existence of a third-party funder and the arrangement between the claimant and the third-party funder, how then does a settlement go through, particularly in a situation where the third-party funder feels, no, I don't think the settlement amount is good enough from my perspective, whereas the claimant who wants to continue and have a long-term relationship with the respondent feels, well, I think it's good enough for me. So then it boils down back to the question of what was the arrangement in the TPF agreement. But this definitely can play a part in terms of whether a settlement would go through or would fall.
Thanks, Darshandev. I mean, as I said at the beginning, I actually faced this issue. I was acting for counsel for the respondent, and we didn't have a very good case. We didn't know the other side was being funded until the funder showed up at the mediation table. And for me as a counsel, it reiterated to my client what I'd been saying to them, because they were more bullish about the case than I was. And actually, when they saw the funder on the other side, they said, oh God, maybe Sherina is saying something that's sensible, that we don't have that great a case, because the other side's the claimant and they've got to buy in. It was really interesting what played out at the mediation, because actually we didn't settle at mediation, and there was a real blur in that room who was the client, because every time I thought we were getting there, the funder would be whispering something into the ear of the counsel and the ear of the client, and the settlement would keep getting scuppered. So it didn't settle at settlement. My clients walked out of the room because there was no sense. But we settled ultimately over the phone, because both of us counsel had a very sensible counsel on the other side, and we both agreed that it was more sensible for the case to settle, because just as one of you said, you know, even though there is a 60% chance of success, there's a 40% chance of no success. And we ultimately settled, not at mediation, but after. So that was a really live situation that I experienced, and thank you very much. We've actually got a number of questions that have been coming in. Shreyas, can I ask you, there's a question from Kishore. Could third-party funding possibly aid and abet money laundering and spur a wave of frivolous litigation and arbitration? Fantastic question. Shreyas, do you want to take that one on?
Sure. I mean, these are exactly the kind of the fear of the unknown type concerns that we should address frontally. There is no point in dismissing these concerns as being overblown. The very fact that it has been expressed means that it is a view that is held by somebody, and it must be rationally dealt with. So when it comes to concerns around foreign exchange, as I have pointed out myself and Sindhu has confirmed, making sure that they are fully compliant with FEMA regulations and the role of the RBI as a regulator. And these are concerns that are well known, and the allegations of being complicit in improper activity and the fines under FEMA section 13 of 3 times the amounts involved to those concerned is sufficient, I would say, economic incentive to take foreign exchange regulation seriously. So that's that. The second factor, actually, it might temper and not increase frivolity in litigation, because to have access to funding, as Sherina put it, the funder must be convinced of a higher probability of success than of failure. What that exact percentage is may vary from case to case, but it is not every case that would get funded. Therefore, there would be a filter that of cases where the parties are not able to proceed because of a lack of funds. And so the law of the market might just show that some funds fall by the wayside. And that is some claims fall by the wayside because they're not able to be funded by the claimants themselves or to secure funding. And therefore, the froth and the frivolity that is being referred to might even be tempered. Of course, there are situations that you can equally think of where funders could nudge parties if they have taken aggressive positions, and it's a subjective view as to which the litigation is frivolous or not. Especially, you will consider it so if you're on the losing side. But I think in a well-regulated funded market, many of these concerns should be addressed. But I think the concerns will remain if the market remains unclear, unregulated, and ambiguous.
Thanks, Shreyas. That was great. Sagar Kulkarni has asked really important questions as well. In fact, two questions. Sindhu, it would be great if you could address those. How does third-party funders analyze the merits of the case, and is funding decided based on the winning probability of the case?
Sure. I mean, there are lots of things a funder looks at when they're assessing a case, but if you kind of break it down, it's fundamentally about merits. It's about legal merits, and it's also about economic merits, i.e., is it a good investment? So on legal merits, we're going to look at, is the case likely to succeed at trial if it goes through to trial on the law as well as on evidence? I mean, funders have no interest in funding bad cases because we get nothing absolutely if the case loses. Secondly, it's the economic analysis, and I often tell people this, but it's no different to any other investment you make. You're going to look at, how much, the funder's going to look at how much they're being asked to fund, how long is it going to take, what's the likely value of the case, what's the realistic value, right? Not the claim value stated in the claim form. And where does this leave everybody? Does this leave the funder with a good return? And does this also leave the claimant with a fair share of the proceeds? Because we would want both. So when you do the diligence exercise, which is what funders do when they're sort of assessing a case, you look at, there are lots of other sort of little things you look at to kind of do this fundamental analysis. You're going to look at the legal and factual arguments of each side. You're going to look at the evidence supporting it. You're going to look at the theory, the legal theory underlying your damages claim, as well as the expert evidence and how strong or weak those things are. You're going to look at the jurisdiction because that impacts both the likelihood of success as well as the length of the case. You're going to look at the budget. Is it a realistic budget? Is it comprehensive? You're going to look at the defendant. You're going to look at the defendant, their financial history. Can they pay up? If you are successful at the end, and also what's their litigation history? Are they going to be pragmatic and settle, or are they going to drag it out? And likewise, you're going to look at the claimant. I mean, you're going to look at the claimant. Are they commercial and pragmatic? Are they motivated to dedicate the resources needed to run the case? And lastly, you're of course, you're going to look at the counsel and expert team. So actually going back a little bit as well to, settlement and what Darshandev said, a lot of those things, the sort of worst case, scenarios in terms of the litigant and the funder not agreeing on settlement should ideally be taken care of at diligence itself. Because if the litigant that's seeking funding doesn't seem to be pragmatic and commercial, funders will typically hesitate to fund such claimants. Because that sort of preempts and that sort of prevents some of these settlement-based situations from occurring in the first place, right? That's really it. I mean, I think there's lots of other things. You look at who's the expert team. You look at lots of other things. But broadly, I think it'll always come back to: is this going to be a successful investment, and is it going to be a good investment?
And when you say successful, Sindhu, are you looking at that 60-40 split?
Not at all. I mean, I think
okay.
I mean, we're all ex-litigators. Most funders are ex-litigators, and we understand, it's very difficult to quantify, or even if someone does quantify it, I think we'll take it with a pinch of salt. but we, we will look at, the overall merits of it. Is it more likely to succeed or not? And not just 51-49, but is it a good case? So if you had to quantify it, I'd say ideally you want something that's 70% or more.
Right. And what's the minimum claim amount third-party funders provide? I know it's across a very large value, isn't it? I mean, some will go for 10 million will be the base, some will go for 100. What do you think in your experience?
Entirely depends on the funder. I mean, just like other investment funds, different funders have different models. Some want to do lower value cases and limit their exposures, but perhaps do more a greater volume of work. Others take a very different approach and say, we don't want to do quite so much in the by way of investments, by way of volume of investments, but we only fund cases above a certain threshold. A very bare minimum, I say, is, there's got to be enough in the pot for the claimant to have a fair share of the proceeds, for us to have a good return. And in doing that assessment, you need to look at the jurisdiction involved. Are there going to be adverse costs and exposures as well, etc. So you would, putting all that together, the truth is different funders have arrived at dramatically different answers in terms of what their minimum thresholds are.
Thanks, Sindhu. Yeah, that's exactly my experience as well. We are nearly getting to time. Well, probably one last question. Shreyas, this is a question from Rama Apaju. How is attorney-client privilege dealt with within the third-party funding landscape in India?
Just leaving out India for a minute, certainly attorney-client privilege is a very important concern, and confidentiality in sharing documents with anyone else, be it a funder or anyone else, is vital to ensure that you maintain a confidentiality and privilege. Now, in some of the regulated markets, you do have guidance on this, and you do have suggestions that the funders agree to respect the nature of the privilege and confidentiality that is governed by those arrangements. But look at it this way: adding India to the mix, you might share details of the claim with certain advisors. I'm sure your lawyers would advise you to keep lawyers copied on such communications. It could be a chartered accountant, or it could be a claims expert. It could be somebody else who subject matter expert that you need to show some documents which are otherwise governed by attorney-client privilege. So there are, even in an unregulated market, there are many ways in which, in such situations of non-disclosure agreements, of course, but beyond that, also ensuring that lawyers are kept copied, that there contains a header, each email to say that it's attorney-client privileged communication. I don't see how communications with the funder would be much different, in the sense that the funder would be, in a way, advising or evaluating the case in the first instance before they choose to fund. So I'll stop there.
Thank you, Shreyas. I mean, we are spot on time to close. There are loads of more questions, and what I would request is, please do feel free to email the panelists with your questions so that they can be answered, if not on this, because we don't have time on this forum. So as expected, and as Neeti had told me, this would be a really popular session, and clearly it is. Bilshan, over to you to close the session.
Thank you very much, Sherina. Thank you very much to all the panelists. It was a very interesting session, and I don't think I'll do justice by summarizing the detailed and in-depth content of what you've shared in just the 30 seconds that I have left. But I'm very grateful to Darshandev. It was very interesting to hear perhaps the more conservative approach to litigation funding in Malaysia. But also thanks very much for sharing some of the practical regulatory aspects, I would say, that apply in Singapore and Hong Kong. And Shreyas, same to you. Shreyas, it was very interesting to hear from you about the practicalities and perhaps sensitivities, as you put it, that apply in India, even in the absence of express regulation and express authorization permission, or any decision or judgment of the court on litigation funding. And on that aspect, Sindhu, thanks for, first of all, explaining a bit more about the risk allocation that applies in litigation funding, but also it's reassuring to hear that funders are not put off by the fact that there's no express permission in certain jurisdictions regarding third-party funding. Sherina, thanks very much for putting together the content and the structure of this session, including the practical scenario towards the end. I don't think I have the time to talk about it, but last but not least, probably other key takeaways for those who've been with us since the beginning of the session were short fun facts from some of the panelists when I introduced them. I'm very sorry, Sindhu, I forgot to ask you about your fun fact at the beginning, and that is not out of an intention to blank you, but we are very keen to hear about that just before we finish off this session.
I thought I dodged a bullet, actually. You shouldn't be sorry at all. No, I don't know if I have a fun fact about myself off the top of my head. I'm sure there are many, to be honest. But I can't tell you this. And when I'm not financing litigation, I suppose I'm usually found outside and in the water. So maybe we should swap jurisdictions as well. I love swimming outdoors. You know, pool, lake, ocean. I'm not picky, but that's where I'd like to be when I'm not at work.
Great, thanks very much for sharing that. So that concludes this session. The next one is at 3 p.m. on enforcement of arbitral awards in India, which I'm sure is going to be another interesting session. So see you then.